I'm very pleased to introduce the second session on the legal aspects of banking. My name's Andrew Johnston. I'm a professor in the law school and I'm one of the directors of SICL. I'm very happy to have you all here today, see so many familiar faces and some new ones. The first speaker this morning is Professor Richard Werner from the University of Southampton. I'm just going to briefly introduce him. He's a well-known figure both on the academic scene and in the Twitter sphere. He's been at the University of Southampton since 2004. He's the founding director of its Centre for Banking, Finance and Sustainable Development. He has various other positions there. Richard is not simply an academic. He has a long professional career behind him, including in particular a distinguished spell in Japan. He's written one of the most influential books on the Japanese macroeconomy, Princes of the Yen, which became a #1 bestseller. 2005, he wrote another important work called New Paradigm in Macroeconomics, which correctly predicted the collapse of the UK banking system. And as long ago as 1995, he coined the term quantitative easing to describe large-scale central bank purchases of government debt. The second speaker is going to be Rosa Lastra. She's not here yet, so I will be sitting here sweating and watching my watch, waiting for the door to open. But in the meantime, Richard is going to talk to us about banking and law, the legality of banking. Thank you.
Thank you very much. Thank you very much. It's a great pleasure to be here. Jay, thank you very much for the invitation. I think it's a great idea, this conference itself. So I think it's wonderful that I can participate in this. I think we need more dialogue between lawyers and economists, finance and accounting people. Slightly changed the title, Banking and Law, the Lawfulness of Banking, on the advice of a friend of mine who's a banking law activist, Wesley Wright, who's here with us. Now, the legal facts of banking. Banks do not accept deposits. Banks do not lend money. Not all banking practice is lawful. Maybe that one has emerged quite obviously as we read the papers about bankers being hauled into law courts, which is an ongoing process. So I think it's fair to ask, well, is banking unlawful or even illegal? And if so, what are the policy implications? So let's go through this. Banks do not accept deposits. We have here a much considered, applied, referred to and distinguished ruling, reported, Foley versus Hill, 1848. The relation between a banker and his customer who pays money into the bank is that of debtor and creditor, the banker being liable to repay to the customer the money which he holds for him when required to do so by the customer. When the customer pays money into his account at a bank, it ceases to be his money. It becomes the banker's money, and he can deal it as his own. He's not, vis-a-vis the customer, in the fiduciary position of a trustee or quasi-trustee holding the money for the customer as for a certificate trust. Distinguished barrister at law at Inner Temple, Henry MacLeod, also confirms this in his writings. It's not unusual for people to say, I've got this much money at the bank, but that expression is entirely erroneous. You don't have money at the bank. A customer has no money at his bankers. He has nothing but a right of action to demand so much money. That raises a number of legal problems. The customer is not usually aware of this and considers the deposit a bailment or held in custody or in trust or warehousing, and perhaps in the older days, as is actually the case with non-bank financial institutions. And bank customers may not be aware of the difference. So with a stockbroker, your money is held in custody, in trust, but not with a bank. And of course, the normal intuition would be, well, where's my money safer? Do I give it to XYZ stockbroker in the stockbroking account, or pay it into a big named high street bank X? You sort of would like to think, well, hang on, banks surely should be sounder than stockbrokers dealing and wheeling. But no, the law is very clear. It's held in custody with a stockbroker and is not at risk if the stockbroker goes under. But at the bank, it's not held in custody. You've given a loan to the bank, your general creditor. But because people don't know this, no consensus ad idem exists. And so the contract, therefore, can't be enforceable. And that goes both ways. So you can't enforce getting your money from the bank. And we'll look at the other side when you get a loan. Now, when you lend to the bank, there's no explicit loan contract. Well, why not? I mean, aren't we supposed to have a loan contract when you lend money to the bank? And of course, that would help. I mean, there's a reason for contracts to make sure that there is consensus ad idem. If we don't have one, well, people don't really know what's going on. So isn't that a breach of various consumer protection regulations and laws and financial promotion laws? Or it may be the argument is made that the standard bank terms and conditions are considered a sort of general loan contract that you generally consent to, and then, case by case, that is enacted. But that will create a number of other legal problems if that is the case. I think it's fair to say at this stage there is misrepresentation going on, mis-selling. We've got mis-selling scandals of various products, but perhaps there's a more fundamental mis-selling of current accounts, savings accounts going on. Let's consider the other statement. Banks do not lend money. When a loan contract is signed, it's considered a promissory note. Promissory Note Act 1704, Bills of Exchange Act 1882, which the bank purchases. That's what's happening. So banks don't lend money. No bank has ever lent money. Banks are in the business of dealing in securities, such as loan contracts, and, importantly, creating credit. We'll look at that. So the bank purchases your loan contract that you've just signed because there's a signature, there's a date, there's the obligation expressed in the contract, therefore in conformance with Bills of Exchange Act, promissory note. And the banker purchases this now, but how's the banker paying? Well, not with money, but with the bank's own credit. To quote MacLeod, the credit the banker creates in his customer's favor is termed a deposit. These banking credits are, for all practical purposes, the same as money. They cannot, of course, be exported like money, but for all internal purposes, they produce the same effects as an equal amount of money. They are, in fact, capital created out of nothing. Is this lawful? Nemo dat quod non habet. How can you give or lend something that you don't have? Now, as it turns out, this bank credit and money creation is the source of 97% of the money supply. And while that was disputed at some stage by some economists, we've got now the first empirical evidence, a paper published last year, demonstrating this empirically that this is the case. And of course, this is now also endorsed by the Bank of England. That creates a number of legal problems. Let's look at the process of money creation. How exactly do banks do it, and why can other firms not do it? What is it that, makes this specific to banks? Because surely, if companies could do it, they would probably try to do it. So let's consider this comparison between the stockbroker, which is a non-bank financial institution, very similar to banks in many ways. And we've just heard Goldman Sachs was Goldman Sachs was just a stockbroker and probably still is in other countries, but we know in the US became a bank, and recently also in the UK became a bank. So clearly the distinction is very small and not really noticeable by casual observers. Let's compare that. And we look at the case of the stockbroker and the bank granting a loan to the customer. What makes the difference? So we have a loan, £100, Could be 100 million, obviously, more likely, billion. Double entry accounting. So we consider the changes in the balance sheet. The stockbroker has assets and liabilities. And as you know, these have to be reported, and they're part of the regulatory system and the requirements in company law and so on, to report all these and have proper accounting. So stockbroker gives a loan, purchases the promissory note, the loan contract, therefore an increase in assets of the 100 billion. And when, of course, the lender has now also an obligation to pay the money. So when that obligation is discharged, an asset will be reduced, cash or, if it's gold stocks or deposits will be reduced. Therefore, balance sheet plus minus zero, no impact. When the bank does this, the story looks different. So we have the purchase of the loan, 100 billion, increase in assets, but somehow the discharging of the liability, well, if it is discharged, the payment of the money is recorded as an increase in client deposits by 100 billion. So the balance sheet lengthens, and that is clearly a crucial difference. Now, many of us know this, but I thought it was very important to actually dissect this a bit further and find out, well, how is the bank able to do this? I mean, it looks convincing, right? I mean, many of us have been convinced for decades by this. So let's break the process of granting a loan into two steps. Exchanging the loan contract, but not yet paying out the money. And secondly, making the payment required by the loan, what the whole purpose of the loan is. So step one, exchanging loan contract only. So the stockbroker and the bank, they purchase the loan contract, promissory note, which accounting-wise is accounts receivable. That's why it's an asset. They will get, it's the customer, the borrower is obliged to repay the money. Asset, as we saw, increases, 100 billion. And then we're saying, artificially, we delay this now. For some reason, for convenience of the customer, we're not yet paying out the money. So the stockbroker still owes the money. Therefore, it's an accounts payable item that has to show up on the balance sheet as a liability of 100 billion or million, whatever we said. So then the balance sheet increases, it lengthens. Let's look at the bank. So the bank does the same. It signs the contracts, but the customer says, "Oh, don't give you the money yet. Don't book it yet for various reasons. We'll do that next week." Okay. So we have the increase in assets, the accounts receivable, which is also called a loan, of course. Same thing, increased by 100. And because the bank hasn't paid it, we have an accounts payable liability. The balance sheet lengthens. So we see the stockbroker and the bank are identical. In fact, any normal firm that does the same thing, and of course firms can give loans to other firms and so on, will increase the balance sheet by this amount. So let's look at step two. So just to remind ourselves, step one is again shown here at the top. Step two is at the bottom, making the loan payment. With a stockbroker, when the money is paid and the liability of the lender to pay the money is discharged, the accounts payable goes back to zero, right? They don't have an accounts payable liability anymore. And that can be done by paying out the money. So some that cash or deposits go down by 100, and therefore the balance sheet goes back to zero. Let's look at the bank. And we know, obviously, that's what makes the difference. So far, things have been the same. Now we realize what happens is that the bank simply changes the recording, the booking of its liability items. What actually is an accounts payable liability arising from the loan contract is set to zero, and a new liability is created called client deposit. Now, accounting-wise, therefore, the balance sheet stays the same. The bank, as we see, is still stuck in step one. They have not discharged their obligation. So the bank reclassifies its obligation to make the money available to the customer as customer deposit, but no customer deposited the money. The bank didn't deposit the money, nobody deposited the funds. So clearly that is a misrepresentation, false accounting, which certainly in some countries and at some times was considered a crime. The founder of Stockholm's Banco in 1666 was imprisoned for fraudulent bookkeeping. Now, you could argue that the borrower lent the money to the bank, since, as we learned, deposits are loans to the bank at law. Okay? But the borrower did not have the money to lend. We're back to nemo dat quod non habet. You can't lend what you don't have. The borrower came to the bank for a loan and not to lend money to the bank. I mean, I think it's hilarious. And clearly, again, there's no consensus at Edom. Borrowers don't realize they actually have to lend the money to the bank. That is the situation at law. And of course, there's other problems. Loan contracts are promissory notes issued and traded, okay? Because the bank purchased the loan contract. If we're now saying, and we're finding out now that a deposit is a loan to the bank, then when the bank lends and books this as a deposit, the bank has issued a promissory note that is dismissing loan contract. And if we argue that the standard terms and conditions are the loan contract, well, then it's clearly contravening the Bank Charter Act 1844, which says very clearly banks are not allowed to issue promissory notes, which is why MacLeod has maintained, I think throughout his life, that banking practice is illegal in the UK since 1844. And there's a quote, I don't have time to quote it, where he expands on that, why he thinks it's clearly illegal. If we have time, we can go back to this. So the bank is not discharging its obligations. I looked up a law dictionary. The most common way to be discharged from liability is through payment, but no payment takes place. The bank remains at step one when the money had not been made available to the borrower because the bank didn't actually make any money available. Now, if you have an accounts payable item on your balance sheet as a company, there's a number of ways you can meet this obligation, discharge it, but I have not seen anywhere where it says, oh, just delete the accounts payable and write customer deposit that you've invented. So what is the authority used by banks to reclassify their accounts payable items in this way as customer deposits? I'd like to know. And therefore, do borrowers have an obligation to repay such loans, which are not enforceable at law, if you follow the logic? Therefore, borrowers could repay bank loans by issuing private credit, which would be equal consideration in a legal and certainly in an accounting sense. Now, there's some other issues, because we have to stay aware of the broader issues. The money supply is created by banks in this way. And it's this act of suspect bookkeeping that enables the recurring banking crises, because if banks create money, we always have to ask for what purpose, because credit creation is a powerful tool for good or for bad. And if money is newly created and lent for financial transactions which are not part of GDP, they don't contribute to national income, it will have a negative impact on everyone. How? It will drive up asset prices. It must, because you've got new money creation pumped into asset markets. And that is the initiation of a Ponzi scheme, a pyramid scheme, which, if large enough, and that happens fairly quickly, will crash, of course, and lead to a banking crisis. Banks have less than 10% in equity, so the assets, all this newly created money, purchases of these promissory notes, just needs to drop by 10% in value, and the banks are bust. So that's very easy to happen. So since this is a Ponzi scheme, a pyramid scheme, well, that's actually illegal in most countries. So that would be another reason to doubt the lawfulness of banking practice. Just to point out how these things fit together and answer also the question of the gentleman, what happened in Japan for the last, over 20 years. There's three cases when banks create our money supply. This credit creation can be productive or unproductive. If it's unproductive, it's always unsustainable and costly for society. And that can be consumer credit, if that happens on a large scale. You've got money creation, but no increases in goods and services. So more demand chasing existing amounts of goods and services. You must get consumer price inflation, that's well recognized. But when banks create credit and money for financial transactions, you will get these asset booms and therefore asset bust, because this only works while there's an ever increasing amount of credit for financial circulation. So as soon as that slows, that's when the bubble ends, and then you have a bust banking system and a crisis, and the bankers want to be bailed out. But you can use this for good if banks create credit for productive purposes, for the implementation of new technologies, increasing productivity in a broad sense, including environmental improvements, just new investments, then you will get growth without inflation. So full employment is also possible through productive credit creation, and successful economies have ensured that bank credit creation is going into this green box. The East Asian economies during their high growth periods, Japan, Taiwan, Korea, China, and of course what happened then in Japan was the Bank of Japan gave instruction to the banks to increase their financial credit creation through credit guidance, so that they would create an asset bubble which busted the banking system. And then since then the Bank of Japan has kept credit creation basically negative or zero, so you can't get GDP growth. You must have credit creation for GDP transactions for growth. That's a physical requirement. So by creating credit, banks increase the amount of claims on finite resources. That's, you could argue, as an Austrian school argument. So there's some economists that have said, for this reason, there's something wrong with the banking system. They just create these claims on finite resources, many more claims than there are actually resources. That can't be lawful. The ownership rights of the community must be affected if these claims on resources are issued. How is that dealt with? The banks give wrong and misleading impressions. That the reported amount of deposited money is somehow a truthful claim on finite property, but in actual fact that's not the case. At the same time, we have the issue of usury. Banks charge interest to the borrower, although they did not give up any resources when they provided the bank loan. In fact, we've heard the borrower has to lend money to the bank. Well, how come the bank is the one charging the higher interest? Certainly the opportunity cost justification of interest is out of the window. Now, so back to the question, why don't other companies not also create credit like banks? Well, I've identified the client money rules as a crucial regulatory instrument that gives banks the unique ability to create credit and money out of nothing. Well, these say that, these are client money rules from the FCA handbook. A firm, on receiving any client money, must promptly place this money into one or more accounts opened with any of the following: central bank or a bank. Therefore, when you're just a normal firm, then this is a bailment or money held in custody, it's held with somebody else. And therefore, you're not in charge of the bookkeeping. You can't invent fictitious claims, fictitious customer deposits that haven't taken place. So you can't create money. But the banks, here's the next one, they're exempt from the client money rules. So that's the crucial bit. The client money chapter does not apply to a depository when acting as such. The client money rules do not apply to a credit institution in relation to deposits. And therefore, they can keep their own accounts and then they can invent fictitious claims on themselves, fictitious customer deposits. That is how this creative accounting is possible, the client money rules. But that raises many problems. In fact, the whole thing is in a regulatory and legal muddle, because banks are not depositories. We just heard depositories are exempted from the client money rules, but banks are not accepting deposits. So are they really then exempted from the client money rules? Maybe not, and therefore they're actually in breach of it. They should therefore not be able to create credit. And also, there's the other aspect. Accepting loans from firms is not a regulated business. So ordinary firms could operate as de facto banks with the power to create credit if they are dealing only with other firms, so the consumer protection regulation doesn't apply. Transparently labeling these deposits as loans and operating a system of transferable consumer credits based on these loans that can be then used to settle claims. And I think this is what the Swiss have done in the VIA system of private company credit. So you then could render bank regulation obsolete. It also means that ordinary firms could discharge their existing bank loan debt by simply reassigning credit created by normal firms in this way. Tender private sector promissory notes not issued by banks but ordinary firms in order to discharge ad law their debt obligations, because they should be equal consideration. Other regulatory models that I'll just quickly state and then wind up. Bank regulators and central banks, as we saw, continue to use themselves this very misleading terminology of deposits and lending. I also wonder what's the implication of this new FSB, Financial Stability Board inspired G20 regime of bail-ins. So they're saying, and the G20 agreed, our bank deposits can be used to rescue banks. But why? Hang on, there are no bank deposits. These are loans to the bank with general creditors. There are other general creditors. Why should depositors be uniquely disadvantaged? I mean, they're creating a whole new ranking, hierarchy in bankruptcy proceedings. Where's the justification? What's the legal basis? This seems to be discriminating against general creditors called depositors by convention. What about competition? Banks create private credit. It's a private sector activity. Ordinary private credit does not have to be accepted for settlement, but the government requires tax payments to be in this particular form of private credit, that issued by banks. That's a competitive advantage of banks, and so I agree with Ed. There is this implicit government backing of some private sector entities. How is this justified? And so when we keep in mind this credit creation and disaggregation, final comment on policy solutions. When banks create too much financial credit, as you see here, broad credit creation in Japan going wildly out of hand in the 80s, that's excessive credit, that's fueling an asset bubble. As soon as it slows, this happened in 89-90, then the whole thing crashes and you have a recession. You could end it, of course, at no cost to the taxpayer by increasing credit creation. There's various ways central banks can do this. That's a topic of other talks I've given. But that's the causal factor. And so Ireland, Spain, I mean, these crises are not surprising at all when you have credit growth of 30% in Ireland or 15-20% in Spain, while GDP is far, far lower, 5% perhaps, then you know you get a crisis. Now, the banking behavior is determined mainly by central banks. Central banks have had all the necessary powers to ensure productive and sustainable bank credit creation, but they've not used these powers to that effect. They've chosen to say, oh, laissez-faire. No attempts have been made in the past 20 years to channel credit creation to productive purposes. So the revealed preference of central banks has been vast credit cycles. Central banks are ultimately responsible for the misbehavior of banks. Therefore, when some people say as a policy reform proposal, we need to take away the power of banks to create credit, okay, and give it to the central bank and have the central bank as the only institution creating money, I would say that's not a good idea. We would be further infinitely increasing the centralization of power in the hands of already unaccountable and excessively powerful central banks. It's better to make bank behavior transparent, accountable, and sustainable, and that's what we have the law for. So I think all the lawyers should be called to help with this. Banning bank credit creation for transactions that doesn't contribute to GDP is an option. Central banks could have done that. And we should create a network of small community banks. So I entirely agree with Malcolm. Because they tend to lend for productive purposes, and there hasn't been ever a banking crisis because community banks have lent too much to SMEs. There is no such thing. It would also create competition in banking, real competition, and real choice in banking. Now, Germany has, in my view, the best example of this. There was no crisis. Credit creation stayed in line with GDP. And that's because 70% of the banking sector here is the green parts, local cooperative banks, the Volksbanken, People's Banks, and Sparkassen. There is 1,700 of them. In the UK, it's the other way around. More or less, well, they don't exist, and 90% of banking is 5 big banks. In Germany, these big banks are only 13% of banking. So that's, I think, the way to go. There's more reading in these books. Thank you very much.
Thank you very much, Richard. Are we going? I was going to go for the second speaker, but do we want to take? We can take a question now. We can take questions for 10 minutes now, I think. So, Anna, would you like to?
I have many questions, but so. Well, money takes many forms these days, so how would you classify repos and things like that in terms of whatever aggregates you want to do? That's one question. Lehman Brothers was not a bank at the time, so systemic risk does not come from banks. It's also false that small banks are not connected to large money banks and that they don't overinvest in mortgages and that they haven't been forever crisis in normal standard banking, and it's not even true if you ask my co-author who's German that the German banking system is so beautiful. So I even don't disagree with that. But the main question I have is, what you're saying that taking deposits is somewhat different than taking a loan from the depositor. Okay, it's a semantic thing, and that making a loan is different than making an investment in a financial asset, which could be done with equity, or if it's not called credit, it's called a convertible, or it's called an equity, or it's called something else. What's the difference? So you're investing in something, and how do you know what's contributing to GDP anyway? I mean, people invest in all kinds of companies invest in all kinds of things. Why is credit a different kind of investment than other investments in the economy, including in financial assets? In other words, in somebody's bonds or stocks or something else.
Yeah, thank you very much. Can I respond directly? I start with the last point. How do we know what contributes to GDP? Well, national income accounting, they've solved that problem 70 years ago. And why is credit so important? And what's the link between credit and those clearly identifiable units and parts of GDP, according to national income accounting? Well, why is credit important? And perhaps this links to why your co-author maybe seems to be not so in favor of the German system. I believe his publications never mentioned bank credit creation as the source of the money supply, but treated banks as financial intermediaries. In other words, the legal reality and the actual economic reality of banks as creating the money supply is not recognized by a lot of economists. And that's a big problem, and also regulators. In fact, the whole regulatory regime of the Basel approach, focusing on capital adequacy, is of course blown out of the window once you recognize banks create the money supply. So if you think, oh, we can prevent crises by raising bank capital, stricter Basel rules, well, it's not going to prevent the next crisis because banks create the money that will become the capital. And if you doubt this, look at Barclays Bank 2008. They needed, what, 12 billion pounds or something. And they didn't want the government to intervene. So they thought, we read some of this work by these guys who say banks create money out of nothing. Well, we need a bit of that. So, okay, we just create money out of nothing and use that as capital. We just need a counterparty, a strong man. Somebody with a big checkbook, Qatar, okay. So they went to Qatar and said to the sheikh, well, why don't you borrow money from us? We lend it to you, you purchase our shares with it. It's money creation out of nothing, booked as an asset, as the loan on the bank balance sheet. That's how it's created. And then it comes as a liability in the account, customer deposits of the sheikh of Qatar. And then as a liability swap, you draw that down to zero and you purchase the newly issued shares. And this is what they did. And the shares were even collateral for that loan contract. Now, because the sheikh was perhaps not so interested in breaking Companies Act 2006, which very directly forbids this. They had to pay him, apparently, according to Financial Times, 300 million in bribe, which seems to be what the SFO is investigating. I think they should look at the more fundamental issues as well of creating your own capital out of nothing. So that's one issue. What is money? Well, it can be clearly identified. I think it's been a fudge in economics to say, oh, we don't know what money is. Look at the textbooks. They've been saying for 50 years, oh, nowadays it's so complicated. Nobody knows what money is. Well, that's nonsense. That's why we're looking at the law. Together with empirical economics, we know money is created through the act I've described, credit creation, creating deposits. The deposits is the money supply. And that's why credit is important, because all the money circulating comes from that credit. Now, repos are just securities. And you say it's false that small banks are better. Well, I think it's true that we've had a crisis with small banks in America, the savings and loans. And that's precisely why we need to study and have an international comparison, which I would encourage instead of saying, oh, it's culturally different, and try to identify the key features that make certain small bank systems and banking systems successful and others not. And what we found in Germany, well, as the key features to learn from Germany, which are not cultural, is that they have to stay small and local. They're not for profit, so they're not trying to maximize and extract shareholder value, so such as cooperative structures or the savings banks as local public entities. And thirdly, the regional principle. They will only lend in their local community, and then there'll be a network of them. And this is why we have started the initiative to create the same in the UK, with the Hampshire Community Bank as the first. And we want to set up a network of not-for-profit community banks in the UK, modeled explicitly on the German system.
Okay, thank you. I've got a number of people who want to ask questions, so could you take 5 or 6 in a go?
Okay.
Could we keep them as short as possible? First of all, I've got Ian, I've got Ed, I've got Charles, I've got you at the back who I don't know, and I've got Sarah, and I've got Beata, in that order. And Trevor. So that's about 8 questions. Keep them all to being strictly questions, please. So starting with Ian.
Ian Peel, University of Glasgow, trying to reframe this as a question. So, focusing on the legal dimension, you characterised loan contracts as bills of exchange. Now, those of us who were brought up in the old-fashioned sort of school of law remember the definition of a bill of exchange. Bill of exchange is an unconditional order in writing. Order, meaning it's a unilateral act. It's not a bilateral contract. A loan is a bilateral contract. A bill of exchange is a unilateral order issued by one person, and it's the credit of the person issuing the order which determines the credit quality of the bill of exchange. So we can say that, for example, in international trade, where bills of exchange are prominent, the exporter who issues a bill of exchange is creating credit in favour of the importer who needs the credit to make the import. So there's a conceptual issue there, I think, in terms of the characterisation of loans, and that may have implications in terms of how you carry forward that analysis. I had a secondary question, but in the light of the number of questions that there are, I'm going to leave this at that.
Okay, thank you. So, Ed?
To turn my comments into a question, let me begin by saying, why didn't you finish the chain of transactions? People do not borrow, or whatever we want to call a loan, in order to keep money in the bank. So the next step is, where does this money go? And in banking, we distinguish between on-us checks and those on other parties. The ones that go to other parties have to go through central banks' money, shall we say. So what's really at issue here, it seems to me, what you're talking about is the increasing concentration of the banking system, where there's more on-us checks.
Okay, next I think it's Charles.
I was actually going to ask exactly this, make the exact same point as Ed made. You stop the whole process too soon, meaning that nobody borrows in order to put the money back. at a negative interest rate spread with the same bank. They use it. And that leads, in most cases, to a payment being made through the central bank. And the important issue, as Ed was saying, is the degree of reflux. And you go back in the 19th century to the whole issue about the laws of reflux and differing reflux. And you want to just take it further.
Thank you.
Yeah.
Yeah. Very briefly, is shadow banking banking? And does not depositor preference linked to variance and so on actually address some of the issues you're making about what is in the book?
Right, and Sarah?
It's sort of turned into two observations. Thank you very much. I love the point about small community banks and productive lending. And I wonder, given you were talking about the 19th century, whether you know about sort of it's a really interesting discourse from the sort of mid-century years, sort of sandwiched between Foley and Hill and studying the powers observations. Real concerns that actually local banking and decisions sort of resting locally with people who are sort of central figures in a community could actually lead to problems, because actually you were too tied into community interests to make objective and prudent decisions. So I have some scepticism about this, because this is very much a battle between the provincial banking sector and the sort of increasing metropolitan central elite, I think. But there certainly was a concern that a lot of provincial banking could give banking a bad name and could destabilise the whole banking sector, because local interests were too influential in making lending decisions. I think you then clarified things very importantly for me when you talk about this idea of not-for-profit. And quite a lot of the problems here is that banks are being expected to be everything to all men. You know, they're expected to sort of be purveyors and providers of community support, and yes, also generators of profit across deposits, investments, etc., etc. So you sort of clarified it for me when you said a not-for-profit idea, and certainly a lot of the 19th century concerns came out of this idea that banks could do everything, were expected to do everything, but that localism could actually give rise to lots of problems in improving funding.
Sorry, two more, Beata and Trevor.
Thank you. Yes, Beata Schofeld from the Faculty of Law, University of Oslo. First of all, thank you for a very interesting and thought-provoking presentation. I will do as Andrew has instructed and go straight to the questions, although I would love to say more. You mentioned Basel. Have you looked into also how the capital requirements are met with covered bonds and other instruments that are hard to see as capital by any definition? That's the first question. And the second one is, do you in your suggested regime of sustainable banking consider that economic growth is only sustainable if we fully decouple it from the use of natural resources? In other words, could it be seen that it's necessary, is it not necessary to be able to discuss sustainability, to position that work within, notably, the framework of the groundbreaking research on planetary boundaries by Rockstrom and others? Thank you.
And one from Trevor to finish.
I worked for Barclays in 2008, and I disagree with your characterisation of them inventing money to bail themselves out. Is it not relevant that there was a significant transfer of risk to Temasek, who at £7.40 bought our shares, to Qatar, who bought our shares? Is that not relevant?
Okay. Okay. All right. Thanks very much. I'll try to do this in order. So thank you for the comment on bills of exchange. And since I'm not a lawyer, although I've received some advice and Wesley has been helping me, probably there's some words in the presentation where I need to be clearer. And perhaps I shouldn't have said loan contract. I mean, that's our use, but that's part of the issue. We use a lot of banking expressions, and really, what are they at law? That seems to vary. So really, it's a promissory note, and I should have said that. Ed's comment, and also Charles' comment, why don't we go to the next step? We can, clearly, and what we would see then is that, so that the borrower is now making a payment, okay? And so the money, let's say, is transferred, the receiver of that payment has a different bank. So money goes to, well, the money goes, all these expressions, of course, are not true. It's just claims and rights are being transferred. So what happens from a legal perspective is that, or even accounting perspective, is that the bank changes simply its liability to the customer for a liability it has towards another bank. So conceptually nothing changes. And as we know from actual banking practice, I mean, a lot of that is going on simultaneously. And as long as all the banks have, let's say, economists like to make assumptions, let's assume, all accounts are equally distributed and equally sized banks with the same number of customers doing similar transactions, then you can see that no payment at the central bank will take place because banks, of course, net out all their claims on each other. And that's the more normal case, and certainly is the case with a very concentrated banking system as the UK's. And therefore, if one wants, one can discuss these details, but actually we were interested really in the origin, the source. Where does this new money come from? And it's created through that process I described. That's why I'm focusing on purpose on this, to identify how it works, this client money rule, and then fiddling your accounts because you're holding them. You can do that. Shadow banking, is it banking? Well, as a researcher looking at data and statistics, I take the same view as, I think it was actually Paul Tucker who said that in one of the footnotes of one of his speeches or writings, that he said that, well, we're more or less taking care of the shadow banking transactions already, because most of them receive credit from banks and we have the statistics on their loans because they're part of the banking statistics. In other words, yeah, they're out there. I mean, the whole non-bank financial industry is out there. Probably you'd have to look at the case by case. Does this institution have client money on its balance sheet? Is it exempt from the client money rule or not? I think most of them probably are not banks. They're just non-bank financial institutions, and most of the time they receive money from the parent bank, and then we have that data, so we're taking care of it already. 19th century small local banks. Yes, it's a very interesting time period. There were many local banks in the UK, and then this massive drive towards centralization occurred during the 19th century and also just up to the First World War. So that after the First World War, 1919 already, a commission on banking, one of these many banking commissions with a report, they already said, I mean, you could almost publish this today, that the problem in UK banking is great concentration. The big five, names slightly different, not that different, but the big five dominate everything. No lending to SMEs. The loans are too short term. And of course, that's been a problem ever since. So why did the small banks disappear? They were up for sale. And why were there maybe problems? I think you're right. Well, they probably, as in many other countries, didn't conform to what we identified as the key requirements to have a stable small banking system that survives and is sustainable, and that is not for profit, the regional principle. It's basically not up for sale in this sort of structure, and to stay small, which the German banks have largely succeeded. The ECB is doing everything it can now to completely crush them. So in the next 5 years, probably 50% of them will disappear, not because they're shaky or anything, no, because they are the alternative banking that shows how it could be done, so that has to be eradicated. The ECB, through its interest rate policy and regulatory policy, is now unfortunately crushing them. Power, don't the locals then have too much power? Well, Lord Acton says power corrupts, absolute power corrupts absolutely. So the centralization of power is a major theme in the 20th century, and it's really accelerating in the 21st century. I think we have to work against that, and decentralized power and local banking would do that, break up the decision making, bring it back to the local level. Then you can keep track of what people are doing. It's much harder with a small local bank to do strange speculative things than, I mean, who knows what Barclays or HSBC, whatever, what they're doing globally. Finally, sustainable banking. Thank you for that comment. In fact, well, that's another presentation, but I've been doing work on that. We have to connect the financial sector to what's been happening with our planet and the environment, and it seems clear that a key driving force towards ever increasing destruction and making more and more claims on these finite resources through economic growth is the financial system. Through interest, it puts pressure on everyone, to grow, because of course the interest has to be matched in the markets with debt, and equity dividends, so everyone has to grow. What is growth? See, the whole thing is a bit of an illusion. It's not just the banking concepts that are telling us deposits and lendings are a misrepresentation, because economists do the same thing. There is no growth, as any physicist can tell us. We have constant input of energy from the sun and some other cosmic energy, but that's about it. And then it's just transformation within a fairly closed system, and you can't create energy, you can only transfer it. So what is growth? Well, it's an accounting convention designed to record growth. How? Well, we don't record the minuses, the depletion of our assets and finite resources at planet Earth. We don't count that, and then we get this artificial growth, which we need in order for what? Well, to pay the interest, to sustain the financial system. And otherwise it would also be too obvious what's happening, a massive transfer from the many to the few.
Okay, thank you very much, Richard. Let's give a round of applause.